I need you to stop whatever you are doing right now and watch this to the end. Because 3 days ago, something happened inside the United States Supreme Court that every single gun owner in this country needs to understand before their next drive, before their next errand, before they put the key in the ignition tomorrow morning, not next week, not when your attorney sends you a newsletter, right now, tonight. 6 justices said yes, 3 said no. And what those 6 justices just approved changes the legal ground beneath your feet at every traffic stop in every state in America. It does not matter if you are in Texas or California. It does not matter if you have a permit, a clean record, and 20 years of responsible ownership. This ruling reaches all 50 states simultaneously, and the window between knowing and not knowing is the window between keeping your rights and losing them on the side of a road. My name is Ray. This channel exists for one reason: to put information like this in your hands before you need it, not after. Subscribe right now because what I am about to explain has never been covered in plain language anywhere. Let us get into it. Here is what just happened, and I am going to give it to you straight because the way the mainstream coverage is framing this is designed to confuse you. For years, the legal standard at a traffic stop was relatively clear. An officer needed what the courts call reasonable articulable suspicion to expand a stop beyond its original purpose. If you got pulled over for a broken tail light, the officer could not simply start asking about your firearm, demanding to see where it was stored, or using the presence of a legal weapon as justification to detain you further. The gun was a neutral fact, not evidence of anything. That framework just changed. In a 6-3 decision handed down this week, the Supreme Court ruled on a consolidated set of cases involving traffic stops where legally owned firearms were present. The majority opinion, authored by Justice Kavanaugh and joined by Roberts, Thomas, Alito, Gorsuch, and Barrett, held that under certain clearly defined circumstances, the presence of a firearm in a vehicle, even a legally owned and properly stored firearm, can now constitute one valid factor in a totality of circumstances analysis that justifies an extended detention. Read that again, slowly. They did not say a legal gun automatically justifies a search. The 3 dissenting justices, Sotomayor, Kagan, and Jackson, warned in forceful language that the majority's framework opens a door that will be systematically abused in ways the majority refuses to acknowledge. Sotomayor wrote in dissent that the ruling effectively creates a penalty for constitutional exercise and that the people most likely to feel that penalty are not the ones sitting in marble courtrooms debating it. But here is what the mainstream coverage is not telling you. The majority opinion is not actually the most dangerous part of this ruling for the average gun owner. The most dangerous part is 3 paragraphs buried on page 31 of the majority opinion that define what now counts as contributing factors. And those paragraphs contain language that is so broad, so open to interpretation by individual officers at individual stops, that defense attorneys across this country are already calling it the blank check clause. Let me tell you exactly what those paragraphs say. And more importantly, let me tell you what they mean for you specifically the next time those lights come on behind you. The majority opinion identifies what it calls a non-exhaustive list of factors that, when combined with the presence of a legally owned firearm, can justify an officer extending a stop for further investigation. Factor 1, inconsistent answers about travel. If you are pulled over and you tell the officer you are coming from work, and 30 seconds later something you say suggests you are not coming from work, that inconsistency combined with the presence of a firearm now meets the new threshold. Under the old standard, a minor inconsistency alone was not enough. Under this ruling, minor inconsistency plus legal gun equals documented grounds for extended detention. Factor 2, unusual nervousness. The majority opinion specifically uses the phrase observable indicators of unusual nervousness. Defense attorneys reading that language immediately recognize the problem. Nervousness is subjective. It is interpreted by the person with the badge and the gun at your window, shaking hands, avoiding eye contact, an elevated voice. These are now documented contributing factors. And every person in this country who has ever been pulled over knows that nervousness is not evidence of criminal intent. It is a human response to being stopped by law enforcement. It is now being used against you. Factor 3. This is the one that should alarm every gun owner regardless of their politics, their state, or their permit status. The majority includes what it calls inconsistency between claimed firearm purpose and observable circumstances. What does that mean in practice? It means that if you tell an officer your firearm is for personal protection, and the officer decides based on factors he is not required to fully explain that something about your appearance, your route, your neighborhood, or your answer does not match what a person carrying for personal protection typically looks like or sounds like, he has a documented contributing factor. That language is a blank check, and it is now the law in all 50 states. 3 dissenting justices said this plainly. Sotomayor wrote that the majority has handed law enforcement a tool that will be used disproportionately, inconsistently, and in ways that will punish the exercise of 2 constitutional rights simultaneously in the second and the fourth. She is right. And she is also a dissent, which means she lost. So the question is not whether this ruling is fair. The question is what you do about it at your next traffic stop, given that this ruling is now the law. And the answer to that question is not what most people are going to tell you, because most people are going to tell you to just cooperate, be polite, and everything will be fine. That advice has always been incomplete. Under this new ruling, it is dangerous. Here is the reality that this ruling creates. If you have a legal firearm in your vehicle and you get pulled over, the officer now has a legal framework that allows him to combine the gun with any of the 3 factors I described: inconsistency, nervousness, or perceived purpose mismatch, and document grounds for an extended stop. That extended stop gives him more time, more questions, more opportunities to find additional factors, and additional factors feed back into the analysis and justify even further investigation. It is a legal feedback loop, and it was just approved 6-3. The way you break that loop is not with cooperation. The way you break it is with precision, specific words in a specific order, said in a specific tone that cut off the loop at its first iteration. Here's the script, 2 steps. This is what defense attorneys are now telling their clients to memorize in light of this ruling. Step 1, the officer asks any question beyond requesting your documents, any question at all. Where are you coming from? Where are you going? Is there anything in the car? Do you have any weapons? Anything. You look at him calmly. You stay completely relaxed, and you say this: Officer, I mean no disrespect. I am going to remain silent, and I would like to continue on my way. That is it. Notice what just happened. You have not said yes to anything. You have not said no to anything. You have not created an inconsistency because you have not answered. You have not demonstrated nervousness in your answer because you have not given one. You have not provided a stated purpose for your firearm because you have not mentioned it. Every single factor in the majority's new framework requires something from you. This sentence gives them nothing. Politely, calmly, without confrontation. He will push back. He will say something. He is trained to keep the conversation going because every second you keep talking is another second where you might produce a contributing factor. You stay quiet. Step 2. 1 question. That is all you ask. Officer, am I being detained or am I free to go? If you are free to go, you thank him and you leave. You won. If you are being detained, 1 final sentence and then complete silence. Officer, I am invoking my 5th and 6th Amendment rights, and I want to speak with an attorney before answering any questions. After that sentence, no more words, not one. No matter what he says, no matter how the conversation turns, you have built a constitutional wall, and it is built to withstand exactly this kind of pressure. Now, here is the piece that this ruling makes more urgent than it has ever been before. And most channels are not going to touch this because it complicates the clean narrative. This ruling interacts differently in different states based on existing local law. And the interaction creates what legal experts are calling collision zones, situations where the new federal standard runs directly into state-level protections or state-level requirements in ways that could trap you no matter which way you move. Collision Zone 1, duty to inform states. 11 states, including Ohio, Michigan, Texas, Louisiana, and North Carolina, legally require you to proactively disclose a firearm the moment any official encounter begins. In those states, you cannot simply stay silent about a firearm because silence about a firearm is a criminal offense. But under the new Supreme Court ruling, the moment you disclose, you have introduced the gun as a factor, and the officer N has the new framework available to him. In these states, here is the modified approach. You disclose immediately as the law requires. You say clearly and calmly, "Officer, I am a licensed carrier and I have a firearm secured in the vehicle." Full stop. That sentence satisfies your legal duty, nothing more. No details about where the gun is, what kind it is, why you have it, where you are going with it. Those details are not required by duty to inform laws. They are contributing factors under the new ruling. Disclose the fact, nothing else, then go immediately to the script. Oh, collision zone 2, states with expanded firearm privacy protections. Several states, including Montana, Arizona, and parts of the legal landscape in Florida, have passed legislation in recent years specifically designed to limit how law enforcement can use firearm information gathered during traffic stops. In these states, there are arguments available to your defense attorney that the new federal ruling does not override state level protections. This is not settled law. It is going to be litigated. But it means that in those states, the consequences of the new ruling may be challengeable in ways that they are not in states without those protections. Collision Zone 3, states with mandatory insurance verification tied to firearms. This is new and almost nobody is talking about it. 3 states have passed or are actively implementing laws that require gun owners to carry liability insurance and to be able to present proof of that insurance at any point when a firearm is identified during a traffic stop. If you are in one of those states, you do not just need your driver's license and registration. You need documentation for your firearm. Not having it at the stop combined with the new federal framework creates a compounding problem. The bottom line of this ruling is simple, and it is something the dissenting justices said directly. The majority has created a framework where carrying a legal firearm, which is a constitutional right, now carries a legal cost and increased vulnerability to police action that non-carriers do not face. You pay a constitutional price for exercising a constitutional right. That is what 3 justices said in dissent, and that is the reality you are now operating inside of. You cannot change the ruling tonight. You can change what you hear as your action list. Do it before you drive tomorrow. Look up whether your state has a duty to inform law. Look up your state's vehicle storage requirements for firearms. Look up whether your state has passed any firearm privacy protections in the last 3 years. Write down the script I gave you and put it in your phone. Say it out loud until it comes without thinking. Because when the lights come on behind you, the only words you will use are the ones you have already practiced. Write down these sentences right now. Officer, I mean no disrespect. I am going to remain silent and I would like to continue on my way. Am I being detained or am I free to go? I am invoking my Fifth and Sixth Amendment rights and I want to speak with an attorney. 6 justices just changed the rules. The rules changed whether you knew about it or not. The question is whether you change with them before it costs you. Subscribe, turn on notifications, share this with every gun owner you know because the information gap between knowing this ruling exists and not knowing is the exact gap that officers with this new authority are going to walk straight through. Drop a comment and tell me your state. Tell me whether you knew about the collision zones I described. I read every single one. Because this community staying informed is the only thing that keeps this ruling from becoming a tool used against the very people the Constitution was written to protect. Stay sharp, stay ahead, and the next time a patrol car falls in behind you, you are already prepared for exactly what comes next.